What is mezzanine debt and how is it treated?
Well, as we mentioned a little earlier, mezzanine debt is something that sprung up maybe 15 years ago, and it was a way to put additional debt on the property beyond what first mortgages were willing to do. Very often, a first mortgagee will be willing to put financing up to a certain level, and then that debt will forbid any other mortgages on the property. Mezzanine financing is debt which is secured not by the property itself, but usually an entity that holds title to the property. So, for example, you may have an LLC that holds title to a piece of property, and that property may be burdened by a first mortgage. Then there may be a second LLC that owns the first LLC, and that second LLC may have a borrowing that is secured by the interest in the first LLC. That's called mezzanine financing. When you do mezzanine financing, there's no mortgage recording tax because you're not recording the mortgage. The security isn't as good as having a lien against the property as opposed to having a lien on an entity that holds the property. But it was a way to stack on ever-increasing amounts of debt where the first mortgage wouldn't have otherwise allowed it. And there are very often tranches of mezzanine debt. It could be A, B, C, D, with each having maybe higher interest rate and less security than the one before it.
Why do people even use mezzanine debt?
Well, it became very popular to do because it was perceived as a way to get additional financing where normal financing wouldn't be available, maybe cheaper in sort of transaction costs in getting it done, although it might have been a little more expensive or maybe a lot more expensive in terms of rate. It was also a way for sometimes for people to creatively have equity be treated as debt for tax purposes or sometimes for financial purposes where it would have otherwise been equity, and maybe there were reasons it would have been negatively impacted to have it be equity. And there were a lot of commercial reasons that people put a lot of mezzanine debt on. Some from the investor perspective, some people like to put those debts on because they viewed it as an equity stake in the property with equity-like returns, yet they had creditors' rights. So there were a lot of pluses for why people like those transactions. But at the heart of the matter, it was a way to borrow more money without impacting the first mortgage financing.
What happens if the mezzanine debt holder forecloses?
Well, that's a very interesting question. Generally, if the mezzanine holder forecloses, it'll be treated like any other foreclosure. It'll be treated as a sale of the property for whatever the debt that's on that property. What is less clear, and is a matter of some debate, is what happens when senior liens foreclose and junior mezzanines are still in place. So, for example, if the first mortgagee in our mezzanine description forecloses, well, technically, those mezzanine debts are still in place. When the first mortgagee forecloses, he takes the property, except those entities that previously held the interest in the entity that owned the asset and the mezzanines behind it are still there. So technically, those loans haven't been extinguished. For all practical purposes, those loans have no way to be repaid because the collateral is now gone. Or the collateral is there, but it's worthless because there's no asset underneath the collateral now. So different schools of thought have emerged as to what that means. One school of thought says, once the property is gone, it doesn't matter where in the chain that occurred. It's a sale of the property for all the debt because there's absolutely no practical way that the mezzanine debt can ever be repaid. The fact that the mezzanine lender hasn't bothered to foreclose because there's nothing to foreclose on is irrelevant. They all have to exercise their rights. A default on the first triggers defaults all the way up the chain, and they all would exercise, and the only reason they didn't is because they know they're going to lose the property. So a default of any of them should be, a default in a foreclosure of any of them should be treated as a default in a sale for all of them. Another school of thought would say, well, that's nice, but the legal truth is that those mezzanine loans are still in place. And if they're still in place and they haven't come due, they haven't been forgiven, and they remain in place, and you have a foreclosure transaction with the debt that went away, and maybe you have COD with respect to the debts that remain when they come due and aren't repaid. Now, obviously, having COD on that transaction is probably going to be a lot worse than having a capital gain transaction. Won't always be, depends on the timing, depends on the basis of the asset. If you have a high basis in the asset, so you have a loss on the foreclosure transaction and COD, and they're both ordinary income and happen at the same time, you probably don't care. But like we said before, invariably bad things happen at the absolute worst possible time, and the results can be pretty horrific if you think you wind up with a capital gain and maybe ordinary income in a different period or something like that. Now, there are sometimes ways to deal with cancellation of indebtedness income that could allow you to defer or exclude that income, but that's a discussion for another day.
Okay. Can the seller or mortgager be the buyer at a foreclosure?
The answer is yes. There's no legal reason why the owner who's being foreclosed can't be the purchaser at the foreclosure sale. The problem with that is there are some significant tax implications that go along with that that could have the effect of creating an ordinary gain on the transaction or cancellation of indebtedness in the transaction, which wouldn't exist if the seller was not the purchaser in the foreclosure, because there are related party rules which have negative implications if you're selling depreciable real property among related parties or acquiring debt at a discount among related parties. So legally, the seller could be that purchaser. There could be significant tax reasons why the seller would not want to be the purchaser. There could be ways to structure around that with the proper planning.